In this video on the Lucy Letby case, we're going to examine 25 decisions from Judge James Goss that went against Lucy Letby during the trial. In fact, in compiling this list, I struggled to find a single decision made by Judge James Goss that went in favour of the defendant. Number 1. Allowing the worthless witness. The entire debacle, which is the conviction of Lucy Letby, could have been avoided had an application by the defence to exclude the evidence of Dr. Dewi Evans from the trial been allowed. It should have been very clear to Judge James Goss how unreliable Dr. Evans was as a witness, considering that Lord Justice Jackson wrote a letter indicating that he had previously described a report written by Evans as worthless, indicating that he made no effort to give a balanced opinion. There can be no worse assessment of any evidence provided by an expert witness, and since then other cases have emerged in which Evans was guilty of similar conduct. In response to this, Goss made the scarcely believable argument that it was up to the jury to decide whether or not Evans was a legitimate expert. This is frankly utterly preposterous, as anyone that gives expert evidence in court should arrive in the court as an expert, otherwise what is the point in having experts in the first place? Anyone could give evidence and the jury could just decide whether or not they were credible. This was an obvious example of buck passing on behalf of Goss, and a pretty gutless one in my opinion. Number 2. Allowing the RCPCH report to be excluded. In 2016, a report from the Royal College of Paediatrics and Child Health indicated that the neonatal unit at the County Chester Hospital was performing suboptimally. The Royal College made a raft of recommendations that were to be enacted and was significantly critical of the standards of the neonatal unit. For some reason, Judge James Goss decided that this was irrelevant and excluded the report from the court case. This is scarcely believable, considering anyone with any medical qualifications would consider this decision to be completely lacking in logic or foundation. In the years which have followed the conviction of Lucy Letby, it has become increasingly clear that the neonatal unit at the Countess of Chester Hospital was deeply inadequate for the acuity of infants that it was dealing with, and in fact the situation was so bad that Dr. Shu Lee suggested that the neonatal unit should have been closed down completely. Indeed, the building in which Lucy Letby worked was later closed down as suggested and is set to be demolished. Number 3. Allowing the CQC report to be excluded. To deal with this briefly, another report from the Care Quality Commission was also deemed to be irrelevant by Judge James Goss. This report was not as stringent or detailed as the Royal College report, but still made significant criticisms of the neonatal unit at the Countess of Chester Hospital. Number 4. Allowing the full details of Lucy Letby's grievance procedure to be excluded. This aspect of the trial was covered in Stuart Gillam's recent video on the blocked workplace grievance, so I'm not going to go into all of the details here. But you can see some of the text from this on the screen now. It is again incredible that the jury weren't allowed to hear about this, considering that Dr. Breary and Dr. Jayram were instrumental in the case going to court in the first place, and also gave evidence against Lucy Letby during court proceedings. We know now that both Breary and Jayram faced potential disciplinary proceedings for their conduct on the unit, and had waged essentially a 2-year campaign against Lucy Letby before then being involved in the police investigation and being allowed to give evidence in court. This is crucial contextual detail that was denied both to the court and the jury. Number 5. Allowing the prosecution to present its entire case before the defence. This was another application made by Ben Myers to allow the defence to present its case for each infant individually, rather than allowing the prosecution to present its entire case before the defence was allowed to respond. While I have been informed that this is normally the way that court cases are run, considering the fact that the prosecution was then allowed to speak for effectively 7 months unencumbered and uninterrupted, it does seem that Judge Goss could have allowed the structure that Myers requested and that this would have been significantly fairer. Indeed, in one episode of the Daily Mail podcast, various people who observed the trial indicated that they'd already decided Lucy Letby was guilty even before they heard the defence. This included the so-called journalist Liz Hull. Number 6. Rejecting an application for no case to answer. In my recent video on this topic, I demonstrated how the defence made an application for no case to answer with regard to the air embolism cases, which was almost universally founded in completely legitimate arguments that we now know to be correct. This was rejected by Judge Goss, meaning that the spurious evidence of Dr. Dewi Evans would once again go unchallenged. Number 7. Allowed statistical inferences to be made. It was ruled quite early on that statistics would supposedly not be part of the Lucy Letby trial, but then Judge James Goss allowed the prosecution to make all manner of statistical assertions and inferences from a shift chart that was also allowed to be part of the prosecution case. These were all based on statistics, even though the prosecution never engaged a statistician and produced statistical arguments that have no merit whatsoever. This was never explained to the jury, and the prosecution was never prevented from doing any of this. Number 8. Judge Goss barely overruled anything during the court case, no matter how ridiculous it might have been. So there are countless examples of this during the case. There is the infamous Pajama Gate. There is the discussion regarding a shredder. There is the infamous paper towel issue. There are comments made regarding whether or not Lucy Letby could recall being born. There are all kinds of other arguments and ridiculous comments. I would say what many people would regard to be the bullying of Lucy Letby in cross-examination was not interrupted at all. All of this was allowed. I cannot find any interruption from Judge Goss at any point during the court case, except on one occasion when he tells Dr. Dewi Evans that he'd already told the court several things that he was telling them once again. I cannot find any evidence that he overruled a single thing that the prosecution did at any stage during the court case, and certainly nothing that the prosecuting barristers did. Number 9. Meaningless evidence from supposed eyewitnesses was allowed to drag on for an inordinate amount of time. Now, this is one of the most egregious aspects of the court case for me. The fact that so many people were allowed to go into the witness box and give evidence and provide statements and so on, who we know for a fact had nothing to offer in terms of having actually witnessed anything, because it was agreed evidence that no one had seen Lucy do anything wrong. Even so, the prosecution lied about this in the closing statement and claimed that one of the mothers had caught Lucy Letby red-handed, which is categorically untrue. But none of the witnesses that appeared in the witness box at any stage, who were relations of the infants in the court case, had any medical understanding or knowledge, and nor did they witness anything. So in my view, they shouldn't be part of the court case whatsoever. Now, the ridiculous extent of this is perhaps best exemplified by the fact that grandmothers of the children were allowed to give statements to the court. It's one thing having parents in court. In my view, that should never have happened because they had nothing objective to contribute. It's very sad that they lost their infants in some cases. We all feel sympathy for them, but a court case should be comprised of objective evidence, not emotional testimony. But to allow the grandmothers of the children to provide statements to the court is frankly beyond the pale. In the first case that this occurred, in the first grandmother's case, we found out that she was asleep when critical things were occurring. And in the second case, we find out that the grandmother wasn't there when the key events related to child O happened, so she had nothing to recount in relation to that whatsoever. And then she later on concedes that she couldn't actually recall what had happened because she was too busy consoling the parents. Now, I want you to consider that the Royal College report on the neonatal unit was ruled not relevant by Judge James Goss, but a grandmother saying that she can't remember anything but her daughter was upset, that was considered relevant, and the court heard about that. Number 10. Prevented the jury from reading reports prepared by Dr. Michael Hall. So, although Dr. Michael Hall was not called as a witness by the defence, he had prepared reports on each of the infants involved in the court case, and these were full of medical information. It should be emphasised that Dr. Michael Hall is a highly regarded neonatologist. He's part of the Hawdon review and would have been the most qualified person who appeared in the court case if he'd been called as a witness. Now, he had written an array of reports that I'm pretty confident would have been of a higher standard than the reports written by Dr. Dewi Evans, and the judge ruled that the jury do not need to hear about any of this medical evidence because Dr. Hall wasn't called as a witness, but the jury does need to hear about a statement from the grandmothers of 2 of the infants. I mean, to me, this is just an absolute scandal. Number 11. Judge Goss allowed the study by Professor Arthurs to be used in court. Now, in retrospect, this study actually provides exonerating information for Lucy Letby, but as it was used in the court case against Lucy, that's not particularly helpful for her during the trial. And it's quite an extraordinary exchange we see here, where there's a discussion between Myers and Professor Arthurs, and then Judge Goss asks about the study as the jury has not seen it. Indeed, Judge Goss has not seen it. So this is another study that's going to be discussed here. Professor Arthur says the study was carried out for children up to 18 years old in 2015 and looked at 35 cases, with 10 having some gas in the larger vessels. The study was published, peer-reviewed, and available in literature. He tells the court probably none of these were premature babies. The study was performed independently of the trial, the court hears, and was prior to Professor Arthur's own review for babies carried out later at Great Ormond Street Hospital, involving hundreds of cases. So what he's referencing here is a study that was published, that was peer-reviewed, and that was available in literature, none of which applies to the so-called study of Professor Arthur's, and yet the judge has just allowed that to be used in the case. Perhaps he doesn't understand this. Perhaps he's completely ignorant about the way science works. Perhaps he doesn't understand that it's important that something has been published. It's important that it's been peer-reviewed. It's important that it's available in literature. It's important that people have actually seen it. Perhaps he doesn't realise all of these things, but he nevertheless allowed this mysterious study that we know nothing about, that we've only got Professor Arthur's word on. He allowed that to be a central part of the court case, and it was given scientific and medical credence. Number 12. Allowed any item of evidence, no matter how weak. So we've discussed earlier, one of my earlier popular videos that I made was this bizarre paper towel trophy accusation that was made by the prosecution, where so many things were fabricated and so many ridiculous assertions were made, and yet we never saw Judge Goss step in. This was all allowed to be used evidentially in the court case, and there are so many other examples. There's Pajamagate, there's Shreddergate. There are so many other things that are fabricated, that are just made up. There's no evidential support for them, but it was all just allowed to be said, to be used as evidence, allowed to be put before the jury without any interruption, without any contradiction, without any objection from Judge Goss whatsoever. All the stuff about Lucy supposedly altering entries in Datex, there's no evidence for this whatsoever, but it was all allowed to be put before the jury, and it is still repeated to this day as if there is some foundation for it. In fact, it's often repeated as if it's a fact, or at least that it has some form of substance, when it is completely fabricated. And in fact, I've yet to encounter a single item of evidence that Judge Goss said you can't use this in the court case, despite the fact that the court case goes on for 10 months and it's full of absolute unmitigated rubbish. Number 13. Rejected the input of Professor Richard Gill during the trial. So, discussed this briefly, Professor Gill made an effort to provide the court with information during the trial, and that was dealt with, shall we say, less than favourably by Judge Goss. Number 14. Allowed the prosecution to change the date for Child C, which couldn't possibly happen in a standalone case. So one of the many infamous aspects of the trial of Lucy Letby is this case of Child C, in which Dr. Dewi Evans was allowed to change the date associated with the collapse of the infant during the court case. Now, that was controversial enough in itself, but of course, if this was a standalone murder that was being alleged, there is no way that it would be possible to say, oh well, the murder didn't happen on this date, or the key incident didn't happen on this date, it happened on this date instead. But that was just allowed to happen. There was no effort by Judge Goss to overrule this or to require any form of explanation. The only reason it was even explained was that Ben Myers cross-examined Dr. Evans on this matter quite thoroughly. Obviously, this was a ridiculous and farcical aspect of the court case. Number 15, report of Dr. Jane Hawdon excluded from evidence. So, as you can see here, there is no reference made during the court case to reports of neonatologist Dr. Jane Hawdon, who examined the infants and made no reference to any potential foul play whatsoever. This was just excluded from the court case, whereas the arcane theories of Dr. Derry Evans were allowed to be discussed at great length, and he was of course considered to be a legitimate expert. Number 16, allowed a majority verdict from the jury. So in August 2023, the jury was directed by Judge Goss that they could return a majority verdict rather than requiring unanimity after the jury was reduced to 11 members, which we'll discuss later in this video. If unanimous verdicts were required, then Lucy Letby would still be in prison at this point in time, but she'd be facing only 3 charges, which would radically alter the entire picture and dynamic of this court case. However, Judge Goss, in his wisdom, for some reason best known to himself, decided that majority verdicts were acceptable, even though it is already known that majority verdicts are associated more readily with miscarriages of justice. Number 17, anonymity orders were granted for countless witnesses for no justifiable reason. So you can see reporting here from The Guardian at the time. It was ruled that 9 of the doctors and nurses who worked alongside Lucy Letby on the neonatal unit at the County Chester Hospital would be granted anonymity. There appears to be no reasonable justification for this. To this day, no one is really sure why this occurred, and it would usually require extraordinary circumstances for this to be allowed. As is stated here, in the UK, witnesses are not usually granted anonymity as a routine matter. It is treated as an exceptional measure and as a last practicable resort. The main reasons would usually be to protect the safety of witnesses, protect another person, prevent serious damage to property, or sometimes prevent real harm to the public interest. The court must also be satisfied that anonymity is consistent with the defendant getting a fair trial and that the witness would not testify without it. So I cannot see anything even remotely resembling that in this case. I cannot see any way that this was essential to protect the safety of witnesses or to protect another person or to prevent serious damage to property or that it prevented real harm to the public interest. And as for the defendant getting a fair trial, this hindered Lucy getting a fair trial, if anything. So it's really difficult to understand why so many anonymity orders were granted when this would not usually occur. By contrast, let's think about what happened to Lucy Letby. She was never granted anonymity because the police made it inevitable that she would be named and identified in 2018. And then she was dragged through horrible coverage from day one that was particularly amplified during the court case and then immediately following her conviction. She will never be able to be anonymous, and indeed she'll probably have to seek an assumed identity once she is inevitably exonerated. Number 18, a juror was dismissed from the case. I don't wish to dwell on this too much because I think of all decisions this was the most justifiable. It wasn't realistic to expect the court case to pause or be stopped or cancelled at this point, and we can assume that there were legitimate reasons for the juror to be dismissed from the case. However, this certainly didn't help Lucy, as one less juror coupled with a majority verdict worked against her. Number 19, dubious summing up. When one examines the summing up of Judge James Goss, it was seriously weighted towards the prosecution on numerous points. I don't think this was deliberate. It may have been to some extent due to complacency and also due to a lack of understanding of more nuanced issues related to medical matters. What is certain, though, is that Judge Goss repeatedly favoured the prosecution in the way that he described things during his summing up. Number 20, did not permit the jury to have a copy of his summing up of the case. So this is a little known point, but you can see this mentioned here in July 2023, that the jury requested a copy of the summing up of Judge James Goss. Now, it seems incomprehensible to me that he refuses this and says the short answer is no, you can't. What you can ask for is to be reminded of any particular piece of evidence. You cannot have a rerun of my summing up. Now, why on earth would that be disqualified and disallowed when that can only surely assist the jury and its decision-making process? I cannot possibly imagine a legitimate reason for this. It just seems like a rather uppity, self-regarding decision, like, oh, my summing up is too important for you to have a copy of it. Why couldn't James Goss provide a copy? It just seems completely unfair, and again, this would likely have worked against Lucy Letby. Number 21. The jury don't need to be certain of the particular method of murder. Now, in my opinion, this was a particularly, shall we say, unwise direction from Judge Goss, and I'll read this out. You are not detectives. If you are sure that someone on the unit was deliberately harming a baby or babies, you do not have to be sure of the precise harmful act or acts. In some instances, there may have been more than one. To find the defendant guilty, however, you must be sure that she deliberately did some harmful act to the baby, the subject of the count on the indictment, and the act or acts was accompanied by intent, and in this case of murder was causative of death. So it seems to me that this is a kind of technical argument that you would often see appear in court cases. So if someone hits someone over the head with a hammer, two adults for example, you may see a technical argument about, was this just a harmful act that wasn't malicious or intended to be murderous, and so on and so forth. It's completely inappropriate in these circumstances where there is a really complex series of nuanced clinical signs in these infants, as we know now from the international panel, and to say, oh, we don't even need to understand what's happened, you just need to be able to say, did someone in this unit try to kill someone, to me is completely unacceptable and frankly ludicrous. And then that leads us into the fact that the jury was told, oh, Lucy was there, it was always Lucy, the it's always Lucy theory as I describe it. Lucy was on duty, Lucy was there all the time, it could only have been Lucy, 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 Lucy. So how could they possibly assess this evidence fairly or rationally? And then we saw in the sentencing remarks of Judge Goss refer to this phrase of murderous intent. And that's what he's asking the jury to look at. Do you think someone had murderous intent? You don't need to understand the medical information. You don't need to understand whether this could have been natural causes or not. You just need to decide, was someone attempting to harm the infants? After being told Lucy was there all the time, it could only have been Lucy Letby, this infant collapsed for no reason, and so on and so forth. So I think this is one of the clearest aspects of which the trial of Lucy Letby was never a fair one and was fundamentally flawed. Number 22. The judge imposed a whole life order for each count. So when Lucy Letby was found guilty in the retrial of child K, she was then sentenced to a 15th whole life term. So obviously one whole life term means you're in prison for life. This means she's facing 15 concurrent whole life terms. And what that also means is that if she'd only been found guilty on one of these counts, she would still be in prison for life. So that's an incredibly harsh sentence, and it means that Lucy Letby must overturn every single conviction and has to win on every single case and every single allegation in this initial court case, otherwise she would go to prison for life, seemingly without parole. And that seems like incredibly strict sentencing to me. Number 23. The judge imposed a whole life order for attempted murder. So Dr. Keith Wilkinson pointed out to me that this decision to impose a whole life order over attempted murder is pretty much unprecedented. We're not aware of another case in which this has occurred. It may have occurred in another case, but it's certainly very rare. And this would mean that, for example, in the case of child K, in which a tube just fell out, if Lucy was found guilty on that case alone, she'd still be facing life in prison over what was described as an attempted murder that is, as we know, completely farcical. Number 24. Unequal attitude to previous convictions in the Child K retrial. So I've spoken to Lucy de Oliveira about the retrial of Child K, and she attended every day of that retrial. And she told me that the referencing of the convictions of Lucy Letby for murder in that trial was completely relentless. It was just constantly, Nick Johnson would say, "You murdered child A, didn't you, Lucy Letby? Then you murdered child B. Then you murdered child C. Then you murdered child D." And he would say all the names of the infants. And he would do this relentlessly all the way through the trial without any objection or interruption from Judge Goss. Conversely, when Ben Myers requested from Judge Goss that he should be able to make reference to the fact that Lucy Letby was found not guilty on some of the cases, Judge Goss ruled this out and wouldn't allow this. Although Lucy was already facing multiple life orders at this point, this still seems extremely unfair. Number 25. No reference to the New Yorker article in the retrial. So it was ruled that the New Yorker article would remain completely anonymous because apparently this would have caused contempt of court if people had known about the massive problems with the original trial. But of course the jury had already witnessed the sort of headlines you see here: "One final act of wickedness from a coward, sadistic Lucy Letby will die in jail." There had been a relentless avalanche of headlines that were incredibly hostile towards Lucy Letby, but in what The Guardian described as the elephant in the room, the court was not allowed to hear about the New Yorker article. When this went before the Court of Appeal, it was decided that the court would not be influenced by all of these headlines due to what was described as the fade factor, although despite the fade factor, they did incredibly quickly find Lucy Letby guilty with regard to Child K after Nick Johnson just said over and over again, "You're a murderer, you're a murderer, you're a murderer." In conclusion, every conceivable decision that could have gone against Lucy Letby did indeed go against Lucy Letby. Every single decision made by Judge James Goss went in favour of the prosecution. This produced what was certainly an unsafe trial, one in which everything was directed towards finding a scapegoat rather than an unprejudiced court process in which the defendant was able to defend herself adequately. I do not make any comment or judgment on why Judge James Goss behaved in this fashion. I suspect there was a large amount of complacency, but I simply don't know why every single decision that he made in this court case went against the defendant, Lucy Letby. That would be for him to explain. What I can say is that it becomes ever more obvious that the conviction of Lucy Letby is one of the most egregious miscarriages of justice in British history. When we look back at the trial that produced this obviously unsafe conviction of an innocent woman, it is perhaps not surprising that it has proven to be quite so unsafe.